Welcome back to Lawyer Stories, where we explore legal dilemmas through real-world situations. Today, we examine a unique scenario touching on common workplace issues. Understanding employment law, even in seemingly straightforward situations, is absolutely critical. This case exemplifies its importance. A long-standing client approached our firm for guidance on behalf of their individual client, Alex. Alex works a salaried position in North Carolina, earning approximately $800 a week. This income isn't quite sufficient for his needs, so he took on a second job in his free time with a family member. The problem's catalyst was an administrative hiccup with his second job's payroll system, ADP. When issues arose, ADP indicated his primary employer held admin status. Proactively, Alex emailed his primary boss, asking if he knew what could be causing the ADP problem. He later called this a dingus move. Unexpectedly, Alex received an email from his boss, clearly meant for a business partner. It expressed significant frustration about Alex's second job, suggesting he be relegated to hourly pay for having free time. The boss even implied another employee could do more for the company than Alex. The ironic kicker was that the mentioned replacement also held two jobs. This accidental email offered a startling glimpse into his employer's true sentiments and intentions. Alex was, understandably, quite shaken and unsure of the legality of such actions and the employer's true intentions. From a legal perspective in North Carolina, an at-will employment state, employers have broad rights. They can typically terminate an employee for any reason or no reason if not prohibited by law. Prohibited reasons relate to discrimination based on protected characteristics like race or gender. Having a second job, even one that doesn't interfere or create conflict, is generally not a legally protected reason. So an employer can legally fire someone for it or for any non-protected reason. Some companies also have explicit anti-outside employment policies. However, the situation gains nuance when considering the employer's proposed solution, moving Alex from salaried to hourly. This immediately raises questions about Alex's current classification under federal law, specifically the Fair Labor Standards Act, FLSA, regarding salaried exempt status. FLSA sets clear guidelines for salaried exempt employees who are not entitled to overtime. They must earn above a certain weekly amount, currently federally $684, and meet specific duties tests related to executive, administrative, or professional responsibilities. Both criteria must be met. Alex's $800 weekly take-home pay, while seemingly above the federal minimum, might mean his gross salary is closer to or even below state-specific thresholds. If he doesn't meet both salary and duties tests, he could be misclassified as exempt. If misclassified, Alex would have been entitled to overtime pay for hours over 40 per week historically. This could mean significant back pay for unpaid overtime. This is critical, as wage and hour claims can be substantial and include liquidated damages and attorney's fees. The employer's motivation for moving Alex to hourly, based on the email, was to address his free time for a second job and presumably secure more dedication. However, this strategy is likely short-sighted and could significantly backfire for the employer. If Alex moves to hourly, non-exempt status, the company would be legally obligated to pay him overtime at 1.5 times his regular rate for all hours over 40. This could actually increase his compensation and the company's payroll costs significantly. Many employees previously on salary discover they earn more when switched to a properly classified hourly role due to overtime eligibility. This is not uncommon, turning the employer's intended punishment into a financial benefit for the employee. So, what are Alex's options and our recommended approach in this delicate situation? First, Alex must secure evidence. Forwarding that accidental email to a personal non-work account is paramount. This serves as concrete proof of the employer's motivation for any future adverse action, crucial for an unemployment claim or wage and hour claim. Second, a careful assessment of his current role is needed. Alex needs to objectively review his job duties against federal and state criteria for salaried exempt employees. Does he manage employees? Exercise independent judgment? Is his primary duty administrative or professional? Third, consider the immediate practical implications. If moved to hourly, Alex should calculate his equivalent hourly rate to maintain pay. He should anticipate if work frequently exceeds 40 hours, as proper hourly classification could lead to increased earnings via overtime. This could turn the employer's punishment into a financial benefit for Alex. He should also clarify new expectations regarding hours and duties if the shift to hourly status proceeds. Fourth, regarding communication, while tempting to respond emotionally, we advise a calm, professional approach. Alex could schedule a meeting with his boss and HR, acknowledging the email and stating full commitment to his primary job. Express willingness to discuss concerns. He might explain, if appropriate, that the second job is necessary to meet financial obligations, a reality for many. This aims to diffuse tension and open dialogue, but confronting an employer directly can sometimes accelerate an adverse outcome. Fifth, a more aggressive legal strategy involves consulting a plaintiff-side wage and hour attorney. Such attorneys specialize in representing employees in misclassification claims for unpaid wages. A private attorney is often the most effective route, especially given state enforcement nuances. If Alex was misclassified, he could be entitled to back pay for overtime. Filing such a claim also provides protection against retaliatory actions by the employer under FLSA. Attorneys often take these cases on a contingency basis, with fees paid by the employer if successful. Finally, and crucially, Alex should quietly begin looking for alternative employment. The accidental email revealed a hostile work environment and lack of trust. Even if he stays and benefits from reclassification, long-term prospects are often limited and daily stress can be significant. Having other options provides leverage and peace of mind. Safeguarding his career and well-being should be paramount, given the revealed employer sentiments and potential for ongoing issues. In summary, while an at-will employer can act against a second job, the proposed salary-to-hourly move opens up Alex's claim for past misclassification and future overtime pay. The accidental email is powerful evidence. Our recommendation: secure documentation, understand rights, manage communication professionally, explore all legal and practical options, and, critically, prepare for alternative employment to safeguard career and well-being. This reminds both employees and employers of classification nuances and action implications. That wraps up another Lawyer Stories. Join us next time as we delve into another intriguing legal case.